If you're fired and you are thinking of suing, there's something you have to do. And if you don't do this, the court can reduce your monetary damages or even reduce the amount to which you're entitled to. So, what is it that you have to do? You have to do what's called the duty to mitigate. You need to be aware that you have a duty to mitigate, which means you have to look for a new job. For those of you who don't know me, I'm Sebastian Anderson, founder of Labor Rights Law. We are the go-to virtual law firm providing legal advice to you in the comfort of your own home about employment, labor, and human rights law. This is all that we do it well, and we love what we do. Today, I'm going to talk about the duty to mitigate. Some of you are probably thinking, I'm the one that got fired, why do I have to do anything? If you're claiming damages for wrongful dismissal, your previous employer's most common defense is that you failed to mitigate. Your former employer will try to prove that you did not do everything that is reasonable to look for a new job to make up for income you lost. If your former employer succeeds, the court may either deny your monetary damages for wrongful dismissal or reduce your monetary damages because you failed to mitigate. So, what steps should you take to mitigate your loss? First, apply for EI in a timely manner. And, if your EI claim is denied, appeal. You are responsible to be proactive and search for alternative comparable employment. Now, this doesn't mean you have to take any job that comes along. You should be looking for new work that is similar in status, hours, and pay to your previous employment. However, the longer you're unemployed, you may be required to expand the scope of your search for future employment. It's also important for you to document your searches for alternative comparable employment as thoroughly as possible. The courts require you to show evidence of your search for alternative employment. We recommend keeping a journal or a record of all online applications you complete, resumes you deliver, interviews you attend, or recruitment agencies you speak with. Keep track of all prospective employers you have contacted. Keep copies of job advertisements, your application, and the dates you attend interviews, etc. If you find alternative comparable employment, it's also good to keep a record of all income you've received through the reasonable notice period, including income received through employment insurance. Other ways that count for mitigating damages could include earning income through your own business initiatives or self-employment. But you must note that re-education, retraining, or pursuing an entirely new career path may be an inadequate means to relieve you of your duty to mitigate. Lastly, like many things in law, the test for mitigation is based on what is reasonable. This means that the extent of your duty to mitigate varies on a case-by-case basis and depends on individual circumstances. But most likely, the courts will take into account the following factors: whether your employer offered you continued employment in another position, your health, the availability of similar employment, the specialized nature of your skills and knowledge, the size of your community, and whether you should accept a position with less pay or reduced hours, or whether you're required to move to find alternative employment. Visit our page in the link below, or contact us to find out what your obligations are and what you are entitled to.